My name is Michael Young, and I'm a lawyer who handles life insurance beneficiary disputes. I've handled a lot of life insurance beneficiary disputes that are resolved through the interpleader process. That's where the life insurance company will file a lawsuit, name the competing parties as claimants, and have a court decide who should receive the policy proceeds. So when clients consult with me and then hire me to represent them in one of these cases, that they very often have questions about the process, understandably. And in some of these videos that I've done, I've tried to set out various stages of a case. But in this video, I thought what I would do is to give an example of a case that I handled in the past couple of years, one that was not resolved quickly, like some of them can be, but instead progressed fairly far into the litigation process. In this case, it was a fairly common scenario. A woman passed away in her 50s of breast cancer. About 10 days before she died, she executed a beneficiary designation in favor of her two sisters and a few co-workers who had helped her in the last few months of her life. However, she was married. She had left her husband her pension benefits, but she had not left him the life insurance benefits. So the husband wrote a letter to the life insurance company contesting that. The insurance company then filed an interpleader, which was in federal court, naming the husband and then the beneficiaries of the policy, the sisters and the co-workers, who then hired me to defend that claim. There was some procedural wrangling and motions and issues regarding staying in federal court, which the case did stay in federal court. And then I took the deposition of the husband, and the other side took the deposition of one of my clients. The other side hired expert witnesses, including a medical doctor, including a couple of handwriting experts, to challenge the validity of the designation that this lady had signed. The claim was that the beneficiary designation was forged. And then we went through the discovery process. About 9 months into the case, I filed what's called a motion for summary judgment. And that is a motion where you ask the court to rule as a matter of law that your side wins and that therefore there's no need for a trial. I had done a substantial amount of work talking to witnesses, co-workers of the woman, friends of this woman, who explained from their perception how the sisters had helped her so much in her time of need, and so had some of the other co-workers, and from their perspective, the husband really hadn't. And they also testified that they believed that the woman had sufficient mental capacity to decide what to do with her life insurance proceeds. And then, I responded to the medical expert opinion that the husband's attorney had obtained, in which a doctor who had never actually seen this woman but had reviewed some limited medical records had testified that she likely did not have sufficient mental capacity. Quite a bit of work went into responding to that, but ultimately, after about 4 months after the filing of that motion, and literally just a week before trial, the federal judge granted the motion I had filed, finding that the husband had not presented sufficient evidence that would justify a trial. He had not presented sufficient evidence that his wife lacked sufficient mental capacity to execute the designation, had not presented sufficient evidence that my clients had somehow unduly or unfairly influenced her to make the designation, and also found that there was just insufficient evidence of a forgery. Just that the experts didn't have sufficient basis for their opinion of a forgery. And in this case, the document had been notarized, and I obtained an affidavit from the notary about the circumstances of his witnessing this woman signing the document. So that's an example of a case that took just over a year to resolve. We went through discovery, and then we went through the summary judgment briefing process, and then waited to see what the court would do. And in this case, it was a favorable decision for my clients.